Hello everyone, my name is Dwight Mitchell. I'm the Executive Director of Family Preservation Foundation. We're an organization dedicated to family first values and the preservation of parental rights. Today in this video, I'm going to go over at a high level my 35 key tips and lessons learned to defend your rights against child protection workers, commonly known as CPS or DCSF in other states. I'm going to go over the beginning, the middle, and the end of the process at a high level of what to do in your defense if CPS infringes on your rights. This video has a companion PDF to download, so you can download this and follow along if you'd like, or you can download the PDF afterwards. If you have an active case with CPS or CPS has come knocking at your door and you wish to learn more, please join the Family Preservation Parental Rights Group and take our Learning and Education training series. It's called the CPS Pro Say Video Help Kit, and information on joining is in the companion video. It helps parents who are not able to afford their own attorney, or based upon the statistics that I've gotten from the judiciary using the Freedom of Information Act. I learned that about 5,000 parents go through the entire CPS process unrepresented. In Minnesota, about 7,000 cases a year are new cases a year are come before the civil court, and out of those 7,000 cases, approximately 1,000 have lawyers when they're brought into the emergency protective hearing, and only about 2,000 have lawyers at the admit-deny hearing. That means about 5,000 parents annually go through this process who are not legally trained, with no help whatsoever. And the pro se information that I've seen out on the website that's put out by the judiciary or by the courts is minuscule. And so the parents, in my humble opinion, are playing with a stacked deck from the very beginning. So I decided to put together this video here along with the companion booklet, and also to put together the CPS training series. I need to advise you from the start that I am not an attorney. I'm not licensed to practice law, nor am I providing you any legal advice whatsoever. I recommend you obtain your own attorney if possible. The information I'm providing is educational only from the things that I've read based on my involvement with CPS. As many of you know, I won my children back pro se, and I have a federal legal rights lawsuit in progress right now for myself and for our association to stop the infringement of our legal rights, which I feel are unconstitutional in Minnesota. So everything that I say, the opinions that I express, are my own only after being involved with CPS and their practices. So please keep that in mind. The decisions you make are your own. You will have to read and understand the law and make your own decisions. We'll give you templates and give you examples and tell you, what's worked for other members. But ultimately, the decision is yours, and when you go into court, you're going in representing yourself. That's what pro se means. It's not, I went into court and said, well, Your Honor, Family Preservation Foundation told me this. No, we didn't tell you anything. We're educating you so that you can make an informed decision yourself. So having said that, I'll get right into it. The index and some of the things we're going to cover today is know your rights if CPS comes to the door. What happens if CPS opens an investigation against you? The court has a court case against you right now. Maybe you're already in the middle of dealing with CPS. Your case has commenced, and you have a case plan or you do not have a case plan. When do you have to follow the case plan? Working with your attorney, termination of parental rights, and if you're successful, a federal civil rights case. This information can be viewed on an iPad or an iPhone or anything of that nature, this video, but the documents and the Pro Se Help Kit and things of that nature are best viewed on an iPad or on a computer. It just makes it a lot easier. If you're using an iPhone, it's harder to read, and you have to scroll through the menu at the top to try and get the information that's required. As you look at the pamphlet, you'll see there's print screens on where to go on our website and what to click in order to get to the information that you need. Everything that we're talking about and the templates and things of that nature are in the file section of FPF. The training and educational section is in the Family Preservation Foundation website, and you'll only be allowed in that group, which is a closed group, meaning only the people in that group can see that information. It's not public, so no one from CPS is going to hear your discussions or the question you ask other members that are in your group who are going through the same thing. The public forum is still going to be on Stop CPS from Legally Kidnapping Children. That's the public group that you can go into if you want to vent or post things related to CPS. The things on the Family Preservation Educational site are just for educational purposes only. So you'll see everything you need to see between the two websites and or Facebook group pages. So please keep that in mind. Also, I'd like to tell everybody, please stop talking about your constitutional rights. Your goal is to get your children back and winning against the state court level. Once you win at the state court level and you get your children back, then and only then can you talk about your constitutional rights and suing CPS. What we're trying to do now is provide you with the knowledge and the tools that are necessary for you to fight back if you don't have an attorney. And if you do have an attorney, we're trying to make you more informed so that you know exactly what to do and what to say as you're working with their attorney. So first up is your first meeting with CPS and your court case. So bullet point number 1 is never ever believe anyone at CPS or the guardian ad litem or the district attorney or even your public defender is your friend. They are not your friend. Quite frankly, they're exact opposite from the start. They all work for the state. Their job is to try and find that the allegations against you are true. By true, CPS screens in and out calls. If CPS shows up at your door, please take it very, very seriously because they do. Someone has put out some allegations against you and CPS believes them, or they wouldn't be at your door in the first place. The thing that's disheartening about Minnesota is that in Minnesota, they do not have to prove any allegations. They don't have to substantiate the charges before they're allowed to remove your children. And other states like New Jersey, where our other office is, allegations come in, they'll be screened in, the social worker will come out to your house, but only after they substantiated the abuse charges and they have the evidence that you have, in effect, abused your child, will they take your child into protective custody. That's not the case in Minnesota, and that's one of the things that we're fighting against. When I say that no one in CPS is your friend, I am only coming at from my own experience. After I read my discovery that I requested, there were 600 pages. I saw all the misrepresentations in my court case, and CPS is not required to put in anything positive in their case. And so that's what got me to understand that they are, in fact, the enemy. They are trying to take your children, and by law, they're not required to put in anything positive. CPS interviewed, in my case, my nanny, my part-time babysitter, the teachers, the ministers, the school. They had the doctors, the dental records. They actually did a police background check on me. So for 52 years, they knew I was a law-abiding citizen. I'd never been in trouble with the law, and yet they withheld all this information from the court. So I can't say very dismayed. I was surprised because, I'm giving them all of this information, and not one of these items appeared in any of my discovery. So they literally withheld anything positive about me as it relates to my child and my family and, what went on. So although I got positive recommendations, and psychiatrists said, after I did my parenting evaluation, that my children should be returned to me, CPS did not give this information to the court. As a matter of fact, they gave the exact opposite information to the court. So keep in mind, they're not your friend. Their goal is to find you guilty. If they're at your door, they already believe you're guilty in the first place. Otherwise, they wouldn't be at your door. One of their requirements before coming to your house, which most people don't realize, is that they screen in the call. What they try and do is find out if it's true. Does the person who actually called an allegation, do they identify themselves? Do they give an address, a telephone number? Is there any verifiable proof? And also, has this call been, or has someone called it multiple times? So if it's the first time and it sounds kind of sketchy, they may not come to your house unless it sounds like it's very, very serious and the person gives their name and address. But if you have multiple calls by the same person or different people, that's when CPS will generally show up at your door and believe the allegations. So keep that in mind. I was surprised and astonished. In my humble opinion, our constitutional rights means nothing to CPS, the court, the state, and as many of you already know or will know, come to know, this is the case. So please keep in mind, CPS is not legally bound to include any positive information in their files or in their presentations to the court. Technically, that's called exculpatory information. If this was a criminal case, they would be required to turn that over to you. But in this civil context, they are not, and they do not do that. So therefore, you're fighting against a corrupt, unjust, imbalanced system from the very start, as it relates to dealing with CPS in your first meeting. So the entire process is government funded. Everyone in the system gets paid from the same boss, from the government. They all know each other. They've been working with each other for years. They're all drinking coffee out of the same coffee pot, standing around the same water cooler. And this includes, but it's not limited to, the independent parenting consultants, the visitation supervisors, anybody doing any kind of evaluations. They're all being paid by CPS, the state or the government. So just keep that in mind as we go through this as you go through this process. You are allowed to request your own discovery. A lot of people are aware of this. What they aren't aware of is how to go about doing this. Like the criminal side, it will not be provided unless you ask for it, and you have to ask for it the correct way. It needs to be in writing. You need to file a copy with the court. Anything you file with the court, you keep a copy of yourself, for yourself rather, and you get a stamp receipt from the court, from the prosecutor, from CPS. So anything that you hand deliver, you make sure that they stamp a copy received, and you also make sure you file this with the court that they did receive it. Details of what wins this case against CPS and proves the allegations against you. So it's very, very important that you read and understand everything, and so that you will have a fighting chance against CPS. Item number two, and this is most important, and for some reason I really don't understand why people don't understand this. You have the same rights as anyone. People know in a criminal proceeding, have an attorney, don't talk to the police, don't say anything. You can't fight your way out of it. They can't come into your house without a warrant. All of the same things that apply in a criminal context apply in a CPS context also. So do not let CPS or the police in your house without a warrant. If they say they have a warrant, ask to see the warrant, read the warrant in detail, make sure that the dates on the top are accurate, make sure it's signed by a judge. And if they don't have a warrant, you don't have to let them in your house. As a matter of fact, you don't even have to open the door. You can talk to them through the door. If you want to talk to them at all and be polite, go out on your front porch. They're there to collect evidence against you. Don't allow them into your house because something that you may feel is benign and nothing is wrong with, they will write up and say something is wrong. If they aren't in your house, they can't say anything. You might have just finished breakfast and had a chance to clean off the kitchen table or dining room table, and they'll come in and write up that the house was messy. So don't allow them in your house. If there is an emergency or something of that nature, the police will kick down the door and come into your house anyway. If they ask to come in, politely say no. No is a full answer. They are there to collect evidence about you. They believe the allegations are true, and they will misrepresent or lie to intimidate you and attempt to con their way into your house. Do not allow it. Just say no, close the door, and move on. Something that you have to keep in mind is that you do have to take advantage of your constitutional rights. You do not have to invite them in your home. If you give them permission to come into your house, you have effectively given up any of the constitutional rights you have as it relates to a warrant because you voluntarily allowed them to come into your house. I found this out the hard way. The police told me they were coming into my house. I let them in the house. I went to the court, tried to get the things they were saying excluded. The judge said, "Did you let them in your house?" I said, "No, Your Honor. They told me they were coming into the house." The judge said, "Well, did you tell them to leave?" I said, "No, Your Honor. They said they were coming in, and they came in." The judge said, "Well, since you didn't tell them to leave, you effectively allowed them to come into the house, and so you gave them permission to come into your house." So that's something to remember and something to think about. Everything that they see or everything that you do or everything that you say is admissible in a court of law, and they will use it. They're taking down notes, they're writing it down, and they're going to put it into their own context and say what you want. The only time the police can really come into your house by force is if they've got a 911 call where someone says, a crime is in progress or something of that nature. At that time, they don't need a warrant, but only if they're acting under an emergency situation and they think that, a child is being harmed and someone called the police on an emergency line. If you can afford to, take your children out of the country prior to anything happening. Say you have relatives that live in another state. I would highly recommend that while you deal with CPS. As long as the children are in the state, CPS has total and complete control. If the children are out of the state, nothing can be happening. They can't order you to bring the children back into the state. So get in the car and drive as fast as you can. Go over the state line. Leave them with your grandparents, your aunt, or someone else if possible. And then you go down and straighten things out with CPS. And when I say straighten things out, have your discussions. Make sure you have an attorney present if possible. But make an appointment to see CPS and don't allow them in the house the first time that they show up unless they have a court order. Number 3 is never speak to CPS without an attorney. If you can afford an attorney, Know your Miranda rights. You have the right to remain silent, and use that right. Above all else, don't say anything. Parents feel that they can talk their way out of it. Oh, if the social worker knows, what's going on, or they'll understand. They can't possibly think, I'm a child abuser. No, they think that because they're there. If they didn't think that, they wouldn't be there. So never admit to yelling at your child, spanking your child, threatening to spank your child, threatening to send your child to bed without dinner, having your child stand in the corner. All of these things are evidence that the social worker will use against you, and you might think they're ordinary. Your parents use them on you. You're using them on your child. You turned out great. You feel your child is going to turn out great. That's not the social worker's way of thinking. And I'll get more into that in government funding later on. If you admit to anything, if you don't keep silent, it really is the kiss of death for you, because anything you can and say will be used against you. And CPS doesn't need anything but allegations to take your child. So if you come forward and admit to whatever they ask you, well then, in essence, you're telling them or giving them permission to do what they came there to do in the first place. Don't say anything. CPS has this propensity, or this, I don't know what to call it. I think it's unfair, but they equate being poor with being neglectful. If you don't have everything, if you don't live up to their standards or what they feel, you should be, or how you should act, they call this neglect, and it's something that disturbs me very much so, because they will take a child away from a parent who they say is poor and doesn't have the money, and they'll put this child in a house, where the parents have money, and they'll pay $1,000 a month for these people who have money to take care of the child, instead of giving the child to the parent who they say needs help, needs beds, or needs foods, or whatever. So our system is really warped and distorted. But I'll get into why they take your child, and they have to take your child because of government funding, and I'll go into that in detail and show you the state statutes in our Pro Se video help kit, so you'll have a full understanding of why CPS takes your children immediately. As a matter of fact, they have to do that according to Minnesota statutes and federal requirements in order to get the government funding. And so we'll go over that at another time, but not right now. Number 4 is never allow CPS to speak to your children voluntarily. If they have to speak to your children, politely tell them no. Can they come into your house to speak to your attorney? Politely tell them no. Then I would give my child, if it was my child, a 3x5 card, that if anyone tries to speak to them, tell your child to give the card to the parent or to the teacher, anything concerning your home life, and just say, if you want to speak to me, my parent or my parent's attorney have to be present, and I will say nothing to you unless my parents are here, or my parent's attorney. And give that to the child, because most states, Minnesota included, don't need permission to speak to your child or to go to school. They need permission to come into your house. So if your child is in your house, they can't speak to them. But once your child leaves the house and your child is at school or is out on the street, CPS, by law, can speak to your child whenever they want. So, please keep that in mind, and don't say, well, they spoke to my child without my permission. They don't need your permission unless the child is inside of your house. So, which goes back to number 5, if the child is out of the state, or if they're with their grandmothers, out of the state, here again, CPS can't speak to your child. And so then they'll have to go and figure out some other way to prove their allegations, and you're not required to bring your child back into the state because CPS says so. So don't think that they can threaten you and say they're going to do something with your child. Your child literally has to be in the state, and I know this because it's happened with a number of our parents where we've told them to take their children and go out of the state, and the case has been dismissed because the child is not within the jurisdiction of Minnesota. So if you're at home, item number 6 is if you're at home and you receive an emergency removal hearing from CPS where you have to come to court or your child has been taken and you have to go to court for your EPC hearing, try and take an attorney with you if at all possible. If not, please understand that this is the county trying to take your children from you, and that you have the right to bring witnesses, documentation, and evidence at the EPC hearing to disprove the allegation. As a matter of fact, that is your goal and that is your right. So don't let a judge tell you that you can't have witnesses, you can't have documentation or anything of that nature at the EPC hearing. The standard in Minnesota is it's called a prima facie case, and that means that the allegations, if proven true, does give grounds for CPS to take your child away from you. So your goal is to disprove the allegation. So if they're saying that you're a drug addict, go to the hospital, get a private drug test. Don't go to any of CPS's doctors or psychiatrists. Always go to your own. Get a drug test and bring it to the court and say, no, Your Honor, I don't take drugs at all. And this drug test was taken yesterday by County General Hospital, and I'm not a drug addict. So the allegations that they're saying are completely false. So that's the goal at the EPC hearing, is to try and disprove the allegations in whatever way you can. Do think if you have anything in writing, if you have ministers, people from church, the community, anyone that can help you disprove the facts are what you need. And the judge must allow you to present your evidence. If that's the whole purpose of the EPC hearing. So if a judge tries not to let you speak or not allow you to present your evidence, then the judge is wrong. If he tries to tell you otherwise, you tell him, no, Your Honor, respectfully. This is the whole purpose of the EPC, for the county to present their evidence and for me to present my evidence and for you to then, weigh the evidence that's been presented and then to make a finding and determination. Whatever you do, don't let it be lopsided where CPS says everything and you sit there quietly. That's not the purpose of the hearing, and that's why so many parents lose their children. Number 7 is that you need to respond to the petition. You're going to get a petition from the court at the emergency removal hearing, and the petition is going to have all the allegations in it. Your job is to respond to that position in opposition by whatever means are necessary. Here again, documentation from your doctors, lawyers, your minister, if you're seeing a psychologist, a psychiatrist, anything that you can bring forward to refute the petition or that's in opposition to the petition, you need to do, and you need to present to the court. And we'll tell you how to do that more in detail in our training series. But you do need to put in your own declaration of facts. So you'll put in what's known as an opposition to the petition with a declaration of facts that's signed and or notarized, depending on the state you're in. And then you will submit that to the court. Here again, 2 copies of everything. Submit it to the court, submit it to the prosecutor. Make sure you get it stamped that it was received. And then you can move forward with that. I advise everyone to put everything in a 3-ring binder. Please keep it organized. You're going to be getting a lot of paperwork. This whole process is paper intensive, and you want to be able to reference information quickly. And you can only do that if you either A, scan it and put it in the computer and put it in the folders, or B, put it in a get a hole punch and put it in a 3-hole binder and keep it organized. I can't emphasize this more. So many people lose their paperwork and the documents, and you got to be able to keep it all together and keep it straight so you can speak to the judge intelligently. You can flip your book to certain pages and have everything indexed and categorized. And That's the only way you're going to be successful. Number 8 is approximately 8 days before any hearing, you're supposed to receive a reports and recommendations from CPS. CPS needs to send it to the court. It's called a court report. If you don't receive the court report at least a week before the hearing, make sure you write to CPS and say, I need the court report, to the guardian ad litem, and say I need the court report. File that with the court also, that you asked for the court report, you didn't receive it a week in advance. You are, by law, they have to give you that report, and they have to give you a chance to oppose it. And that's where a lot of people fall down also. They aren't aware that anything that the social workers say, you can write an opposition, and it must be in writing. They put theirs in writing, you put yours in writing, and you have to give them a copy. That way the judge will entertain it in court. If you come to court and you just say, well, Your Honor, I don't agree, with what they said in their reports. Well, it needs to be in writing. He'll let them present their side. You'll present your side. If you have documentation or evidence, he'll look at that also. And that's all in the court record now. If you don't do that, 9 out of 10 times the judge is not going to allow it, or he'll let you speak, but he won't actually entertain it. It's on the record, but they like things in writing in advance. The court report should be submitted to the court a week in advance, and if you get it in a day or two, you should write an opposition, and that opposition should be submitted to the court so that the judge has the time to read all of this prior to the court hearing. They don't really like making snap decisions right there in court. They like to be able to read things, look at the case law, and then make an informed decision. Some people will have an attorney, some people will not have an attorney. If you have a public defender and a public defender is not doing these things, please write it down. Everything you do with your public defender should be in writing. Do nothing verbally with your public defender. If the public defender is not representing you adequately, you can write the court. You'll have your documentation and your backup. You'll say, Your Honor, I sent him an email on this day, this day, this day. He did not respond to my emails, or this is the way he responded to my email. He told me he wouldn't present my case, or he wouldn't present the facts. But you have to have all this in writing and documented, so keep a journal. I tell everyone, do nothing in writing, especially as it relates to CPS, to guardian ad litem, the county attorney, or your public defender or your own attorney. Do everything in writing and have a copy. Next, I'd like to point out that you never provide your consent for CPS to do anything. The only thing that you provide your consent for with CPS is visitation. If you provide your consent to CPS, you have effectively opened the door for them to do whatever they want. Remember this, if you remember nothing else, a judge cannot order you to cooperate with CPS. CPS has the right to do an investigation. They have to try and prove the allegations. 9 out of 10 times they can't prove the allegations unless you tell them, unless you agree, unless you admit to something. So don't do it. Don't do their job for them. Let them prove their own allegations. Don't let them speak to your doctor. Don't let them speak to anyone without your permission. Do not sign any consent forms. It is not required. Let me repeat that again. Do not sign any consent form for them to speak to anyone. It is not required. Nothing about insurance, nothing about the school, talking to your teachers, talking to your doctors, none of that. They have to do all that on their own, and they can't do it without your consent. So please keep that in mind. The only form you can sign is forms related to visitation. You must visit your child. Try and get as much visitation as possible. If you do look at a consent form, make sure it's not like a blanket consent form with, because usually they'll have one form that has all of these consents where they can go to your dentist, go to your doctor, cross those sections out and say, write NA, non-applicable, and sign the portion for visitation. And then at the top, you can say, this is for visitation only. I'm giving my consent for visitation only. Because usually visitation is done by a third party. It's not done at CPS. Sometimes it is held at CPS, but it's usually a third-party organization that is doing the visitation. So you have to agree to that in writing so that CPS can coordinate the visits and pick up the child and drop off the child and all the things that go along with it. Something else I need to say, which is very, very important. CBS will try and intimidate you. If they take your child into protective custody, don't think that being submissive and cooperative is going to get you back your child any faster. As a matter of fact, it's going to do the exact opposite. In our educational series, I'm going to talk about the CPS timeline, which is very, very important. And the one thing I need everyone to remember, and I tell every single parent, they have 60 days to come to court with evidence proving the allegations. They can't prove the allegations without your help or without your admissions. Please don't give it to them. I tell everyone, you can be without your child for 60 days or you can be with your child for 6 years or whatever. Once you give consent or approval, CPS can keep your child as long as they want. They have this 12-month window, and 90% of the time, they're keeping the children anywhere between 6 and 12 months or longer. So, I tell them it's better to be without your child for 2 months than to be without your child for 12 months or longer or forever. So don't help them. Don't be afraid. Don't let the government intimidate you. Know your rights. Know what you're allowed to do, no matter what they say. If you have taken our classes and you understand the education, then you'll know what they say, what they're saying, if it's true or not, and always ask them to provide you with state statutes or case law and say, okay, you're saying that's the law, show me the law. It's always show me. So never sign any documents that CPS presents you, even if they're telling you you're being uncooperative. Oh, well, you're not being cooperative. You're not going to get your child back. That has nothing to do with it. You don't have to be cooperative. Say, listen, I don't have to be. That's not the law. Show me in the law where I have to be cooperative. You need to prove your allegations. I'll see you in court and trial in 60 days. In the meantime, give me my visitation, and that's that. If they want to interview anyone, simply refuse. And no is a complete sentence. You don't got to explain yourself. You just say, no, I'm not going to do that. I didn't sign any of the forms they gave to me. One of the forms they give to you is that you're going to refund them for all of the expenses that go in line with CPS. And I'm just like, that one shocked me. I said, you take my child against my wishes and you expect me to pay for it? Not going to happen. So I didn't sign any of the forms outside of visitation. So keep that in mind. I guess that one of the biggest things I'm saying when it comes to cooperation, and I'm going to leave it at this, is that everything you say or everything you do or everything you allow them to do, they're going to use to build a case against you. So do not take any kind of urine tests, or do not take do not go to one of their doctors or their physicians or anyone they want you to go to. You don't have to do it until you've had a trial. And I tell everybody, you got 60 days in Minnesota, and they can't make you do anything until you've had a trial. If they say, well, if you cooperate, we'll give you your child back sooner. No, people, that's the exact opposite. That is not the law. If you cooperate, it stops the clock. Now they no longer have to give you the trial to prove you're guilty because you're cooperating now and you're signing up saying, okay, I'm going to do your case plan. Well, then by admitting to do the case plan, you're admitting that you've done something wrong, and that's why you're doing the case plan. And so now the clock stops, and now CPS doesn't have to take you to trial, and now instead of you getting your kids back in 2 months, it's 6 months or a year. So please keep that in mind, that everything you do will be used against you. So, never consent to anything, never do anything voluntarily except for visitation. This is everyone's biggest mistake. Once you do, you've voluntarily given CPS complete control over your life. So say you your case has started and CPS is involved, and they're required by law to put together a case plan in 30 days to present it to the court of what they feel is wrong and what you need to do. You're not required to adhere to that case plan or do anything related to that case plan until after the trial. I don't care what they say. They're trying to get you to do the case plan, trying to get you to have a parenting evaluation and do all of these things so that you can go to their doctors. Their doctors will provide information, and then they'll use this information in court to keep your children. First things first, after my trial in 60 days, if the judge finds me guilty based upon your evidence presented and my evidence presented, then and only then can the judge order you to do a case plan, and we'll go over that in detail in the CPS Pro Se training series. So don't let them say you have to do it. Now, if you are adjudicated and you do have a case plan, or if you're in a situation now and you haven't seen this video until now, and you've already voluntarily agreed to a case plan, you must do everything that's in that case plan, and you must document that you've done everything. Keep a ledger and a journal. Every time you do a visit, every time you go to a doctor, write it down, put it down, get copies of everything. That way you'll have that to present as your evidence in court, and CPS cannot turn things around or twist them. If they say anything that's against what you say, you need to put together your own opposition, again, your own declaration of facts, and you need to present that to the court. Please keep in mind you can't plead the Fifth in child protection proceedings. If you plead the Fifth Amendment, if you stay quiet, that's consent. So you must write out your oppositions. You can't say, well, it's not true and I'm going to keep quiet. No, they have the right to present their allegations, and you have a right to refute their allegations. So, please keep that in mind. Always go to your own doctors if you have a case plan. Never go to a CPS doctor. If they say, well, here's a list of doctors to go to, say, no, I'm going to get my own drug test from an independent resource. Nope, I'm going to have my own parenting evaluation from an independent resource and handle it that way. Anyone you go to that is on the CPS list is being paid for by CPS, and they're working for CPS and they're working for the state. They're not working for you. So you need to go get your own doctors and do your own independent tests. Make no mistake about it. And don't let them tell you you have to go to their people. You do not. They tried to tell me that. I said, no, I'm not. And I went and got my own doctor, and I told my doctor, you can send CPS a copy of the parenting evaluation, but I'm not using their doctors. I got a UA, and then I sent the UA to the court. So everything you do, send it to the court, again, and CPS and the county attorney, so everyone has a copy. In your admit deny hearing, never plead guilty to anything, even, no matter what they say, always deny the allegation and plead innocence. Never admit to anything. Always make them prove whatever it is they're going to prove. Never write anything self-incriminating in your opposition. So if you're writing these oppositions, you don't say, well, I'm going to show them. No, stick to the facts. Whatever they say, write the direct opposition. Keep it small and succinct. Don't write these huge, long paragraphs. Stick to the facts and present your evidence. Keep it as brief as possible, and that way the judge will read it and understand it and take it into consideration. Focus on the most important issues without leaving anything out. It's not what you know, it's what you can prove, and that's always the case. You need documentation, you need video, you need voice recording. Make sure that you're doing everything that the case plan says, and don't give the social worker any reason to say that you're not. If you're recording your meetings with the social worker, if you're doing everything in writing with the social worker, then everything is documented, and everything will be done in this specific time frame. So if the case plan is for 90 days, you need to do everything that case plan says. And if you run out of gas or have a flat tire, you need to have that documented if a tow truck comes because your car breaks down, take the receipt, go to the social worker. My car broke down. I couldn't make visitation. Here's the proof. Put it in email, send it in writing, and make sure everyone has a copy. So she can't say, well, you missed your visitations. If your case plan says you must take weekly drug tests, do not take them with the county social workers. As I said before, go to your own independent person. Anything that you must do according to your case plan, make sure you do it with your own people and never with the county people who are recommended, because they are paid by the county and they want to continue to work, and they want the county to keep sending in people. That's how they're making their money. So they're going to do whatever the county says, and if the county doesn't like the report, they're going to change the report according to what the county says to continue to get that government money. So here again, anyone that you meet, make sure that you record everything. If they refuse to speak in recordings and they don't want to be recorded, that just goes to show you that they're doing something duplicitous and that they don't want you to know or record. If they had nothing to hide and if they were completely above board, they wouldn't mind being recorded. Do everything in writing, and then you'll have no reason not to have proof of what actually transpired. I'm not sure about every single state, but you do have the right to record any conversation that you're a direct part of. So if you're in a conversation, you can record it, and you don't have to ask for a person's permission to record. You're recording your own conversation. If they come back later on and try and say it's inadmissible, say it is admissible, and then go through your state statutes to show that. So we're going to go through next. Okay, discovery. Everyone must ask for your CPS discovery. There's a certain way to ask for discovery. A lot of people say, well, I asked for it and they never gave it to me. Well, you didn't ask for it correctly. When you ask for discovery, you have to put a formal request in to the court that you're asking for discovery. You have to send it to the prosecutor. You can give it to CPS. Most of the time, I tell people just give it to the prosecutor, and prosecutor will get it from CPS. But you can give it to everyone. All of my attorney, even all of my discovery came from the county attorney, even the CPS attorney. It took them a while, and I had to ask like 2 and 3 times, but eventually I received all of my discovery, which was over 600 pages from the county attorney. But here again, you have to document it, and you have to give them a reasonable amount of time. Every 2 weeks or every 4 weeks, you got to go and say, where's my discovery? And anytime you request a discovery, you need to write to the court also. And then you need to go, when you go into the court, say, Your Honor, I asked for discovery 30 days ago, and they still haven't given it. And the judge will order them to give you the discovery. And discovery is ongoing. So you should be getting updates. So if you get your discovery in the first 30 days, 4 months later or 3 months later, if you're still involved, ask for your discovery again. Ask for an update for anything new. Keep copies of everything and keep going back asking for that discovery. Read your state statutes. But before I go into read your state statutes, read every document in your discovery and pull out everything that you have direct proof that is contradicting what's in the discovery. So if the social worker writes up that you're a drug addict and you have proof, from a doctor, or you've taken a drug test that you're not a drug addict, then you need to present that to the court. And so that anything that's in direct contradiction that you find in your discovery needs to be presented to the court in your defense. That leads us into reading your state statutes and what the mandatory requirements are for CPS in the timeline. I go over that in great detail in the training series. So you need to truly understand all of the statutes. You need to read the case law. I'll give you copies of the most recent cases of the last 2 years as it relates to CPS, so you need to understand that and what's involved. I'm not going to lie, it's a lot of work. You're going to find it confusing at first. What helped me was to read the summary at the top and then drop to the bottom and see what the judge's findings and opinion are, then go back up and try and put together how the judge came to his opinion and his ruling based upon the evidence that was presented. And that helped me understand things a little bit better. And then once you understand that will help you in your case. The only way you're going to know a CPS is telling the truth and they're not fabricating or misrepresenting themselves to the judges. If you read the statutes, you know what's required and you have your own documents. This is what I did in order to get my children back. I read the state statutes. I read what they were doing. I filed my own motions, provided the court with the evidence, contradicting what CPS said, and I got my children back. So please keep this in mind and do everything in writing. When it comes to termination of parental rights in Minnesota, there are 2 cases that I'm going to deal with in the training series. It's regarding the children of TR. There's a lot of recent case law that's out there that you really need to understand. When it comes to terminating your parental rights, it's actually very, very difficult. I put the detail in the companion PDF. I'm not going to go over that right now, and I'm going to go over it more in detail in the training series. But no, you need to understand the case law when it comes to termination of parental rights. And a lot of people, they go to the trial, they aren't properly prepared, and they don't know that it's very difficult for the county to prove that you're an unfit parent and that you're never going to change. And that's what most people don't get. They don't fight back. And so they have to prove that, they've tried everything and that nothing they've tried has succeeded and that you're going to continue to be this way forever. And that's not the case. Forever is a long time. So it's really, really a high standard that they must prove. And so you need to understand that very carefully. So we'll go over that also. The next thing I'm going to talk about is knowing your constitutional rights and your Bill of Rights. Something I want to keep in mind, and I tell everybody, don't be afraid to contact your congressman or your senator for help. Write your local newspaper. Seek out information on the internet. You are responsible for winning your case and getting all the resources and bringing all the people to bear that you can to help you win your case. That brings us to working with your attorney. You know the facts. Your attorney knows the law. Your attorney is supposed to be working with you and for you. Everything you do with your attorney, do in writing, send emails, keep copies. If you ask your attorney to do something and your attorney doesn't do it, send a second request or a third request. But your attorney should be working for you, and if your attorney is not working for you, then you need to either get rid of your attorney. If it's a private attorney or if it's a public defender, you need to bring this before the judge, and you need to have this documented also. Your Honor, I asked my attorney something 10 times, or whatever the number may be. Actually, no more than 2 or 3 is actually required, and they refuse to do it. They're not properly representing me. I want another attorney. Don't believe everything the attorney says. I had a high-priced attorney, and I, did what my attorney said, and things just kept getting strung along and strung along and strung along. At the end of the day, I determined that the attorneys are making money off of you. The longer the cases stay open, the more money they make. So it's up to you to understand what the laws are, what the requirements are, what they need to do, and what they're supposed to do, and ensure that they do it. And so please, understand what I'm telling you. Do your own reading. Don't leave it up to the attorney. Make the attorney show you the state statutes and the case law. Anytime they have a recommendation, well, I'm recommending this, say, well, why? Show me the state statutes. Show me the case law. Show me why you're taking this approach. One of the things I learned, which I was quite surprised about, is that each attorney has its own strategy. And people can say, oh, I was misrepresented, and I want to sue my attorney for malpractice. You can't sue an attorney for strategy, not unless they do something like really wrong, like not filing documents that they were supposed to file, or documents you told them to file, or documents the court told them to file and they didn't do it. This is malpractice. But the attorney's strategy is their own. That's why I say it's up to you to win your case, and you need to really understand what it is your attorney is supposed to be doing for you. Your attorneys are playing within confines of the law, and the law in Minnesota is very, very difficult. In my humble opinion, you're playing against a stacked deck when you come in the door, and so you need to understand this as it relates to working with your attorney, so that they're telling, oh, cooperate, it'll go better. Well, they're telling you to cooperate for two reasons. Two, it keeps the case open longer, and they don't have to go to trial in 60 days, and they'll get more money. Don't cooperate no matter what your attorney says. And if your attorney is trying to force you into cooperating, you need to either let go of that attorney, or to advise the judge if your public defender is not doing what you want. What they're supposed to be doing is taking your case to trial in 60 days, nothing more, nothing less. Only after the 60 days can they talk about cooperating and doing your case plan and things of that nature. They will always tell you, oh, cooperate, go along to get along, you'll get your child back sooner. That is not the case. That is not the state statute. That's not the law. So don't let them tell you that, and don't fall into that trap. The minute you do, you have agreed to do whatever CPS says, and then they'll be in your life for as long as they want, 6 to 12 months. That attorney will be getting paid for 6 to 12 months when that attorney should have been getting paid for 2 months and taking your case to trial, winning for you, and getting your child back. So, please keep in mind that the attorneys are there to represent you, but they're representing themselves also. They're running a business. I'm not saying all attorneys are like this, but, it takes a good attorney to do what they're supposed to do. And it takes you being on top of the attorney, telling them, no, here's the state statutes, and here's what you're supposed to be doing within the next 60 days, and that's what I expect you to do. A second thing I'm going to talk about signing is a safety plan. I have mixed views about the safety plan, and this is, here again, my own opinion. If you sign a safety plan, they'll say, well, if you sign this safety plan, we'll let you keep your child in the house. And now you're sitting here saying, well, there's nothing wrong with my house, so why should I sign a safety plan? If you sign a safety plan, you're in essence saying that there's something unsafe about your house, and they're saying, well, sign this and we'll keep the child in the house. That is something you're going to have to decide for yourself in working with your attorney. I can't advise you on that because, as I said, I have mixed views. If you do sign a safety plan, it needs to be as minimal as possible. Like social workers are going to come visit your house every 2 weeks to make sure the child is safe. The safety plan, you do not have to go to a doctor. You don't have to take tests. You do not have to do anything of that nature. It's what do you need to do to make the child safe? And in essence, the social worker just needs to visit your house like every week or every other week or whatever they need to do, but you don't have to do anything for the safety plan. So, go over that in detail with your attorney, or read the safety plan yourself, and you'll have to decide whether or not you want to sign that safety plan or not. I told you about the reports and recommendations. CPS writes that reports and recommendations. Make sure you get that a minimum of a week before the trial, or any hearing date, rather, not the trial, before any hearing date, so that you have a chance to write your opposition to that safety plan. So, you need to do that. It's essential you do that, because if you don't do that, you're essentially saying that all the allegations that CPS are saying are true, and silence means consent, or you agree with what they're saying. They're saying you did 1, 2, 3, 4, 5, and if you don't write an opposition to that or say something against that, then you're saying it's true. This is the number one way that CPS is winning. against the parents. They write up their court report. They put their recommendations in there. Parents don't say anything. Judge says, okay, granted. CPS, you can keep doing what you're doing. So you need to fight back. You need to put everything in writing. You need to get copies of everything. If you don't have the means to go down to the courthouse, send everything certified, mail, return receipt. It costs about $3. Send an envelope with a stamp so they can send you back your copy of the document you filed. And then you can check online, if you have a computer or a smartphone or a tablet, to make sure that your documents were actually filed. Everything is electronic now, so that a lot of these things you can do electronically if you have a computer, and then you'll have an automatic copy, and then you could see that it's filed with the court. If your attorney does not do what I have stated above, and then that means they are not working for you. If your attorney does not come and tell you that there's a 60-day window and that they need to go to trial and prove their facts against you within a 60-day time period in Minnesota, then that attorney is not working for you and you need to find another attorney. In the termination of parental rights section, which we go into more in detail in our training program, this means that the county attorney has filed a petition to terminate your parental rights. This is usually done somewhere around the 12-month mark. They get federal funding up until 12 months. If they have your child, if they haven't returned your child to you, by federal law, after 15 months, they have to seek permanency. Minnesota starts theirs at 12 months. By federal guidelines, it's actually 15. And so technically the only reason they should file a TPR against you is if you are not following your case plan or if you don't do what they tell you to do. So if you're following your case plan and you have everything in writing, that TPR is going to be very hard for them to win. So please keep that in mind. For this area of the process, you definitely need an attorney, because now they're talking about taking away your kids forever. Say you were doing the rest pro se, and it got to this stage where they wanted to file, a TPR. I would advise you to get an attorney, get a public defender, because they're talking about taking away your children forever. And so you really need to understand this section, and the county attorney has to show that the child would be harmed. And that's where a lot of parents fall down in the whole TPR process. The TPR process is different than the child in need of protection or services process. And this is why I'm saying you need an attorney, because they have to show that the child will be permanently harmed. Not that the child is in need of protection or services, but that you are going to harm your child if the child is kept with you. And so that's a very high standard to me, because no one can predict the future. So you really need to understand the case law surrounding the termination of parental rights, and we go over that in detail. Once you go through the petition, once again, you have to make your oppositions, and you have to request additional discovery. You should be getting discovery the whole time, but you should get an update on your discovery. Go through everything once again with your attorney, put out everything in your favor, put out any misrepresentations that the county attorney has put in their documentation, and work to get the termination of parental rights dismissed. As I said, there's two major things that must be met for a TPR in Minnesota. They're in the PDF. I actually cite the case law. I actually cite what's required. And the reason most parents don't win is that because they don't understand the case law as it relates to it, and they don't fight back. To say that a parent is palpably unfit to raise their child is a very, very difficult standard to prove. That a parent will never be fit. there is case law about parents with disabilities and things of that nature. So you need to, really understand all of that. Remember, the parent that has the burden to rebut everything that's introduced. So you need to introduce evidence showing that you are a fit parent. Get doctors, lawyers, your preacher, the school teacher, anybody that knows you. You can bring as many witnesses as you want to court, and each one has the ability to tell you you're a fit parent. Go get your own parenting evaluation. Don't let CPS present a parenting evaluation that came from one of their people. You need to have an independent one or two saying that you are a fit parent. This is very, very important. And so it's important you have everything documented, video recorded, voice recorded, everything. It all comes into play here. And so you have to remember that you're fighting for your child. If you are successful and you get your case dismissed, and only if you get your case dismissed, then you can talk about filing a civil rights case. It's very, very difficult, to file a civil rights case. A, you got to find a lawyer that feels that you have a case that's successful, and B, it takes a long time. The whole process, sometimes I think it's designed to wear you down, to wear you out. So only if you win should you attempt a federal case, and don't attempt a federal case pro se. I started to do mine pro se and ended up doing a voluntary dismissal and hiring an attorney. What I found out trying to do a federal case pro se is that the federal court system doesn't treat pro se litigants correctly. In my particular case, I wrote up everything in detail. I'm well educated. I run a management consulting firm. My whole job is business process reengineering, where I go into the major corporations in the world and I tell them how to re-engineer their business practices to save more money and to become more efficient. With that said, I wrote everything up and I knew everything was valid. I had all the case law, I had all of my facts and all my evidence, and they were trying to dismiss my case. So I did a voluntary dismissal. I went and hired an attorney, and everything they were trying to say that was wrong in my case, the attorney said there was nothing wrong with that. And as a matter of fact, everything that I wrote up, they used. All of the things they were trying to say against me, they said none of that against the attorney. So that just led me to believe that they don't give pro se litigants the same respect that they give legal counsel, although you're presenting the same evidence. So if you are going to try and present do a legal case, please, hire an attorney and to file that complaint for you. Read anything you can on filing federal cases in 1983 claims. You need to understand what a cause of action is. You need to know all the elements that you need to prove. This is everyone's second biggest mistake when they try and do this pro se. There are elements in every single case. So if you're trying to present a case, you have to come down and you have to say, well, here are the elements that I'm trying to prove, and here are the facts that support that evidence. And you need to be able to give that information to the attorney so that the attorney knows how to present this information for you. You need to guide your attorney through all aspects of your case. You know the facts, your attorney knows the law and the case law, and then you in turn should be working with your attorney to control the case. So you have to control everything. You must understand everything that's relevant to your case, and don't just give it to your attorney and say go. That is the wrong. It's a team effort, and so you need to know as much as your attorney, and anything that your attorney is going to submit to the court should be provided to you to read first. Or briefs or filings, I say I want a copy first before it's filed. I read it. If I don't understand something he's saying, or I'm saying, well, why are you saying it this way? Have them explain it to you. That's what you're paying for. You're paying for them to make you understand, because this is your life and this is your case. It's not theirs. They're getting paid either way. So, please keep all of this in mind. Make sure you read all the documents below. Read all the documents in our group page. Read. You can't read enough. The more you read, the more you understand. Read any case law you can on CPS, especially in your state. Each state is slightly different. So I'm only talking about Minnesota because my case is in Minnesota. A lot of these things apply across other states, but you have to find out where things are aligned. But it's based upon state statutes, and each state has its own statutes. So people will call sometimes and say, well, what about Nebraska or Iowa or Mississippi? I'm like, you have to read the Mississippi case law. If you can take what I've said or take our cases and look at your own state statutes and apply it accordingly, then that's what you really need to do. In closing, I'd just like to say this one thing, and then I'll leave the rest for the detailed training series. If you're in the federal side and you decide to try and do this pro se, and you feel that things are not going your way, and the magistrate judge provides a report and recommendation that the case be dismissed, at this point you should put in what's known as a voluntary dismissal and go get an attorney, because things are not going your way, and it probably will happen this way. But, not everyone can afford an attorney, so you might want to do it initially, try and do it pro se. But do not let them dismiss the case. If things are going pretty poorly, do a voluntary dismissal, and then at that time, you can refile with an attorney because you have 6 years to file the case. So that's a very important fact to remember. What generally happens is when you file a federal case, you get assigned a magistrate judge and a district court judge. The magistrate judge does all the preliminary hearings and all the paperwork and things of that nature, and then gives her recommendation to the district court judge, who then in turn makes a ruling. So if you're getting an unfavorable ruling or unfavorable recommendation from the magistrate judge, immediately go in and do a voluntary dismissal, which shuts everything off and gives you the opportunity to find a lawyer, take your case, and have it reevaluated and resubmit your case. That's all for now. Please look for more information on our website, our group page, and take our CPS Pro Se Help Kit video training series if you're in the middle of an active CPS case, to learn all of the details required to properly defend yourself if you can't afford an attorney. Thank you very much, and good luck with your case.